You?
Good morning, sir.
I hope you're well.
Yes, sir, by God.
A bit of a background, first of all. How did this particular bench warrant come to be issued for the Member of Parliament for Akwatia?
Thank you. Thank you for having me. If you have been following this, you realize that the NPP parliamentary candidate for Akwatia another election, he was cited, and you know, contempt is a criminal matter. Hello, can you hear me?
Yes, I can hear you.
Sure. Contempt is a criminal matter. And so once you have been convicted and you are not physically present in the courtroom, the court at that stage, before it goes ahead to proceed sentence on it, pass sentence on you, will need your presence. And so the law is that to issue a bench warrant for the person to be arrested and brought before you for sentencing to be passed. And so on the day that the court convicted the MPP parliamentary candidate for Akwatia, he was not physically present in the courtroom. And so that meant that the court was required to issue a bench warrant for his arrest. It will be produced before the court for a sentencing to be passed. That is why the bench warrant was issued, and it is still pending and very active and can be enforced against him at any time.
The bench warrant is still pending and active.
It is. You know, once a bench warrant is issued, unless the court makes an order to either rescind it, withdraw it, or to cancel it, it's operational and effective, and it's meant to be carried out at any time.
And educate us, what is the process for carrying out a bench warrant, executing a bench warrant? Exactly what usually happens?
A bench warrant is an order from the court directed at a security agency. It could be the police or whichever state agency concerned, but obviously a security agency. Directed at that particular security agency to arrest the person named in the bench warrant and to produce the person before the court. That is what the bench warrant is. And so it is the security agency at whom the order is directed who has the duty to enforce the bench warrant. And so yesterday I heard Honorable Afenyo Markin, the minority leader, claiming that it is a bailiff of the court that has to enforce a court order. With the greatest of respect, that should not be coming from him, because that is not the law when it comes to bench warrant. A bailiff has no power of arrest. They only serve court documents. Court documents. Orders of a court are carried out not by bailiffs. Bailiffs only proceed to serve court documents, or they can also serve a court order on you, but they have no powers of arrest, especially when it comes to the issue of a bench warrant. A bailiff cannot go around arresting people based on a bench warrant. I don't know where, Afenyo Markin will get this from and to say this, especially when he's a lawyer. I take it that he probably good or he was emotional, but that statement is so wrong and very misleading.
And if I also heard Alexander Afenyo Markin's right, they keep claiming that the Supreme Court has intervened and asked the High Court to stay its hands, so that warrant is no longer effective. Is that accurate?
See, that is also a misleading statement, a misrepresentation of the facts. And I don't know why he also say that maybe he wants to cut sympathy from the public, or maybe for whatever reason. You see, they made an application before the Supreme Court asking the Supreme Court to stay the sentencing that the High Court in Kufudua was due and ready to make soon as the bench warrant is enforced and the SCUMI is produced before the court. And the Supreme Court said it would grant the stay to stop the sentencing, not the enforcement of the bench warrant. The bench warrant operates on its own. The sentencing is also another, aspect on its own. They are not conjoined. A bench warrant can be issued at any time for whatever reason. Sentencing is one of the reasons why a bench warrant may be issued. But they are not conjoined. They are not related. They each operate on their own. And so if the bench warrant is for the purpose of producing you before the court, I don't see how you will claim that the stay of the sentencing powers of the court should automatically affect the enforcement of the bench warrant. In any case, the High Court or any other court has the power to sentence you even in absentia. That is, in your absence, the court can proceed to sentence you in your absence. And so, how does that got to do with the bench warrant? Because if the court has basically concluded the case, awaiting the last leg, which is the sentencing, and for some reason you are not even physically present in the country, you are out of the jurisdiction, or it is difficult for the bench warrant to be enforced, are you saying that because you cannot be brought to the court cannot proceed to sentence you? They can, based on good reason, sentence you in your absence, awaiting enforcement of the sentencing at any time that you are arrested. And so, the bench warrant and the sentencing are two independent, aspects or procedures under the law. And so, to say that once the court has stayed the sentencing, and so automatically the bench warrant has to be stayed, is another statement that is not true and should not have been made by a colleague lawyer, Afenyo Markin.
So, now explain to us, first of all, so you're saying that at this point, even though the Supreme Court says stay the sentencing, that bench warrant can be executed against the Member of Parliament for Akwatia at any time?
Yes. That is it. That's exactly what it is. The sentencing they stay has not stayed the bench warrant. In fact, the orders of the Supreme Court does not mention the bench warrant at all. So I don't see why they want to, link the two. Because you see, when an Eskumi is arrested at this stage and produced before the court will have different options available. Either to keep him in custody until the stay of sentencing, is removed or set aside, or gets overtaken by events. Then the court at that stage, if it still has to proceed to a sentence, will proceed with the sentencing. Or if, for example, at the end of the case at the Supreme Court, in the unlikely event that they win, and I strongly believe that they cannot win because their case is not good enough to be able to win. That is my considered opinion. So in the worst case scenario, that they are able to win the case at the Supreme Court and the conviction at the High Court is quashed, then it means that the bench warrant and all of these things effectively will have to go away with it because it will have no leg to stand on. The bench warrant is based on the conviction, not sentencing. It's conviction. So once you are convicted, you are not physically present, then the bench warrant is issued for your arrest so that sentencing can be passed on you. If there's no conviction, in this instance, there will be no need for any bench warrant. You understand? So once he's arrested and produced before the court is also at liberty to grant him bail pending the outcome of the Supreme Court case. You understand?
Yeah.
They also have the option, and at this stage, like me advising them as a lawyer on what to do, they also have an option of producing him before the court and bringing to the court to set aside the bench warrant or to, either cancel it or to rescind it. Either way, to stop it from being operational. They have that option. They can even file a formal application before the court, seeking leave of the court, have the bench warrant rescinded, while the matter is still pending. They have not taken any steps. They have not made any efforts to try to deactivate the bench warrant. And you are there assuming that once the Supreme Court has ordered the stay of the sentencing, then automatically the bench warrant has also been stayed or cancelled or revoked with the greatest of respect. That is not what the situation is. And this should not be coming from no less a person than a colleague lawyer, and the honorable, minority leader. It should not be coming from him.
Because he continues to claim intimidation of the member of parliament. You are saying the member of parliament would be better helped if his lawyers, including Afenyo Markin, they can robe and go to the court with him and ask the court and make a plea to the court to rescind the bench warrant. That's the best way.
That is what they should have done long ago. That is what they should have done long ago, especially after the Supreme Court ordered the stay of the sentence. The next plausible step they should have taken was to go before the High Court and seek the bench warrant also to be, set aside, withdrawn or cancelled, whichever. But they did not do that. And every now and then get a chance, or even they created a chance, because yesterday they went ahead and did a press conference. So it is them creating the chance. And every opportunity they get, all they do is attack the court and try to undermine the integrity of the court. And that itself constitutes an interference in the administration of justice, amenable to contempt action.
You said what is before the Supreme Court is so they are asking the Supreme Court to overturn the conviction for contempt.
Not to overturn the conviction, but to quash it. They are claiming that the court didn't have the jurisdiction, and they are also claiming they were not heard. But these are matters that they have to be able to prove before the Supreme Court, because if you are unable to prove this, then your case will fall flat on its face. But that is what they presented before the Supreme Court. If they succeed, then it is the conviction and the entire, proceedings before the High Court to go, they are going to be quashed. That will be the outcome of it. But I put my considered opinion based on what is before us. I believe that that will be difficult to be able to prove, because the opportunities were given to him to appear before the court to be heard. He refused. So you cannot claim that you were not heard. And if you say the court doesn't have jurisdiction, that too, we have enough evidence to show that cannot be true. So I have no idea, or I don't know how their case before the Supreme Court can have any leg to stand up. But the law is in the bosom of the judges, and we are before them. So we leave it to them to make their decision.
Okay. So far, have you made any progress in terms of what is before the Supreme Court?
We are to appear before the Supreme Court on the 26th of March to argue on the matter. And so the initial preliminary issues have all been dealt with. That is to say whether he could be granted the audience and to be heard by the Supreme Court, because he's a convict on a contempt of court charge. And so that we've cleared that head at the last sitting. And so at the next sitting on the 26th March, we are going to argue out their motion before the court for civil right. We'll see how it goes.
And let me conclude with some education on exactly what you have before the High Court. Is it an election petition?
Yes, it is an election petition. And then also, when he violated the orders of the court, the interim injunction, restraining him from going to Parliament and to seek to be sworn in as the MP-elect for Akwatia, that was a breach, the disrespect of the court, which was contemptuous, a conduct that arises out of it, or therefrom a contempt action. And so we proceeded to cite him for contempt. And it is that which he has been convicted, and he is seeking to have that quashed at the Supreme Court. So we have the pending election petition as well as the contempt action.
Are you by the petition suggesting that your client won the Akwatia parliamentary elections?
Certainly and obviously.
Certainly and obviously.
Yes.
Can be proven?
That's why we are in court. And so if they believe that they won fair square. They should come. They should all stop all this diversionary tactics and this media circus, gymnastics. They should come to the courtroom and let's get it on.
Well, thank you. Thank you very much for speaking to us.
Thank you very much.
Lawyer Isaac Minta Labi is counsel for NDC Akwatia parliamentary candidates, challenging the declaration